My name is David Scher. I'm a partner at Block, O'Toole, and Murphy. I'm very proud to have been part of a team of lawyers and support staff at this firm that handled an important wrongful death case that settled for $15 million. It was an absolute tragedy that involved an accident where a 38-year-old man, a father of 5 children who ranged from 17 years of age down to 2 years of age, passed away while doing his job. This accident occurred in the Bronx, here in New York City, outside of a major hospital. And the project that our client was working on involved hooking up what's known as a chiller unit to the hospital. A chiller unit, in this case, is a massive, multi-ton piece of equipment that would sit outside the hospital on a trailer on the street and be hooked up to the hospital's HVAC system such that it could provide cool air during the summer. Now, this particular hospital's own internal system wasn't strong enough to sufficiently cool the hospital for its patients during the summer months, so they had to bring in this extra chiller unit, and that's what our client was doing. At the time of the incident, the chiller was sitting on a trailer on the street. Our client was working just next to the trailer, almost a little underneath the trailer. And suddenly, without warning, the chiller tipped over, fell down, and crushed our client to death. Tragically, based on evidence that we were able to obtain through witness statements and by talking to a forensic pathologist, it did appear that our client was alive for some period of time and suffered tremendously as he laid under the chiller and slowly died. So it was our job to make sure that the family of this man, his wife and his 5 children, received adequate compensation, if there could ever be such a thing, for losing their father and for losing their husband. This case had significant liability challenges. And the reason for that is that the company that was at fault for the hoist that was holding the chiller failing, and that hoist, by the way, snapped and simply failed. So there was just no question that that company was at fault. But the issue is the company with the faulty hoist had very little insurance money, had very little assets, not nearly enough to satisfy the value of this massive case. So our firm had to think outside the box and be creative. And we brought a claim for this man's estate under New York Labor Law Section 240, which is also known as the scaffold law. Our claim is that the scaffold law was violated because this massive, heavy object, this heavy chiller unit, was not properly secured. And as a result of it not being properly secured, it fell over. That's the type of gravity-related incident that can trigger the protections of Labor Law 240, which holds that owners and general contractors have to follow the law, and if they don't, they're absolutely liable, meaning that they're fully 100% responsible for the resulting damages. The problem was, in order to bring a claim under Labor Law Section 240 to begin with, you first have to establish that your client was actually involved in a covered activity under the law. And for an activity to be covered under Labor Law Section 240, it has to fall within some specific categories. It has to be proper construction work, for example, or demolition work, or alteration, or repair work. In this case, the defense argued that the project at hand didn't fall into any of those categories, and it simply couldn't be covered by the labor law. The defense argued, well, hang on a second. All that was really happening here was a chiller unit was being parked on the street, and a hose was being hooked up between the chiller into the hospital. It didn't involve breaking anything down. It didn't involve building anything new back up. It's really plugging a hose from point A into point B. So the case proceeded in the Bronx through depositions, through discovery, and then to motions. And the defense made a motion to dismiss the entire case based exactly on the argument that I just stated, that this was not a covered activity under the labor law. We made our arguments in opposition, and ultimately the judge sided with the defense and dismissed the case. Now, in that moment, the case was over. And perhaps there are some lawyers, some firms out there who might have given up. But that's not us. That's not our style. That's not our spirit. Certainly not when we're fighting on behalf of a family of a deceased 38-year-old father. So we appealed that decision. And the appeal went to the appellate division for for the First Department, which is one of the highest courts here in New York. And we appeared before the court, and I was honored to have prepared the papers and to argue before the appellate division that day. And what I argued, with the help of our firm and other lawyers on the case, including Dan O'Toole and Fred Aranki, who handled the case from start to finish, what we argued was that this work constituted a covered alteration under the statute. Because even though it did involve knocking down walls or blowing out roofs, we argued that the hospital's air conditioning system was altered, that a physical change was made by the addition of this chiller. It would lower the temperature of the hospital. It would allow the hospital to accommodate patients. And we said that's significant enough. That's enough of an alteration that the court should find that this statute is triggered. And fortunately, we waited several weeks, and when the decision came back from the appellate court, we won. The appellate court reversed the lower court's decision, reinstated the case. The case was back alive again, and we proceeded toward trial. And shortly before trial, after a long private mediation, the case settled for $15 million. Obviously, there's no amount of money that will ever replace this man, no amount of money that will ever take away the grief and the pain that this family will suffer forever. But at least we knew that their needs would be taken care of, their physical needs would be taken care of. They'd have a place to live that would be comfortable. They'd have food on the table, and they wouldn't have to worry about those things for the rest of their lives.